I'm going to start today with a really blunt question.
Mhm.
And I apologize for being a little morbid right out of the gate, but stick with me here. If you were hit by a bus tomorrow, would your family know where to find your bank accounts? I mean, would they know who you actually want to raise your kids?
Yeah, that's a really jarring thought. And honestly, it's a scenario most of us just actively avoid thinking about. The psychological hurdle is massive, you know?
Right, totally.
We just kind of assume things will sort themselves out or that, like, our loved ones will magically know what to do.
Exactly. But the truth is, most people just cannot answer those questions.
Yeah.
And it's not because they don't care about their families. It's really because no one has ever sat them down and explained how to organize this stuff without using incredibly dense, confusing legal jargon.
Oh, absolutely. The jargon is awful.
So today, we're doing a deep dive into the estate planning industry. And specifically, we have a really fascinating stack of sources today. We're looking at a foundational Estate Planning 101 guide, plus 3 local articles out of the Lexington, Massachusetts area.
Yeah, from the Lexington Observer and Patch, I believe.
Right, exactly.
Yeah.
And they focus on an attorney who has completely re-engineered this dreaded process after her own family's crisis. Her name is Pooja Arora, and her story really frames everything we're going to talk about.
It's a brilliant lens for this topic, really, because estate planning is so often treated as this sterile transactional event. You know, you pay some money, sign a stack of paper, put it in a drawer, and forget about it.
Yep.
But when we look at why Pooja built her firm, My Special Legal Planning, we see the actual human stakes involved.
Okay, let's unpack this, because the absolute biggest myth out there is that estate planning is just for the ultra-wealthy, or, that it's only about death.
Which it isn't.
Right. It's actually about love. It's about control. And at its core, an estate plan just answers 3 basic questions for you. 1, what happens if you can't make decisions for yourself? 2, what happens to your stuff when you're gone? And 3, who takes care of the people who depend on you?
And those 3 questions are universal. I mean, whether you have $500 or $5 million in the bank, those questions require answers.
Definitely.
And here's the foundational reality we really have to establish. If you don't write your answers down, well, the government already has a default plan for you.
The government's default plan. I mean, that sounds incredibly unappealing.
Oh, it is. It really is. It's based on what are called intestacy laws.
Intestacy laws. Okay.
Right. These are just the default state rules that dictate who gets your property, who raises your kids, and even who gets to make medical decisions if you're incapacitated. And the big problem is these default cookie-cutter rules almost never match what a modern family actually looks like.
I want to break down exactly how destructive this can be, especially for blended families. So let's say you're on your second marriage, right? You have kids from a previous relationship, and you get hit by that proverbial bus without a plan. You probably assume your current spouse just gets the house, right?
That is the most common and honestly the most dangerous assumption. In most states, under intestacy law, your current spouse does not automatically inherit everything.
Really, they don't.
No, your assets get divided according to a really rigid state formula. It often ends up splitting the estate between your current spouse and your children from the prior relationship.
Oh, wow. So
Yeah.
suddenly you have a grieving widow or widower who might be forced to sell the family home just to buy out their stepchildren.
Exactly. It forces family members who, let's be honest, might already have a pretty fragile relationship into a bitter legal battle in probate court. It's just a mechanical formula that completely ignores emotional reality.
And if we're talking about minor children, the default plan gets downright terrifying.
Yeah.
Like if both parents die without naming a guardian in a will, a judge decides who raises your kids.
Yeah.
A judge, literally a stranger in a robe who has never met your family, never seen how you interact, and doesn't know your values. They're just looking at paper and making a guess.
It's a huge risk. To me, relying on intestacy laws is like letting the DMV pack your parachute. Like, they are definitely going to follow a set procedure, and they'll check their little boxes, but it probably won't account for your specific individual needs when you're free-falling.
That is a perfect analogy. And, this was exactly the realization that terrified Pooja Arora. She has a teenage son, Ishan, who has severe autism.
Right.
He has a highly complex medical history. He's nonverbal, and he will require full-time, dedicated care for his entire life. For a parent in her shoes, letting a random judge decide who takes over that highly specialized care isn't just inconvenient, it's a life or death crisis.
Wait, let me stop you there, though, because I know people listening are probably thinking, are courts really that bad? Judges are supposed to be impartial. Is the probate process actually this destructive, or is this just legal fear-mongering to get people to hire attorneys?
What's fascinating here is it isn't fear-mongering, it's just the mechanical reality of what probate court was designed to do.
Okay, how so? Well, probate is a centuries-old bureaucratic machine. Its primary historical purpose isn't to comfort your family. Its purpose is to ensure your creditors get paid and that title to your property is transferred legally.
So it's about the money.
Exactly. And because of that, it has three massive flaws for the average family. It is public, it is slow, and it is expensive.
Wait, public, meaning anyone can see my business.
Oh, absolutely. Everything filed in probate court becomes public record. Anyone can walk into a courthouse or go online and look up exactly what you own, who you owed money to, and who is getting your assets.
That is wild. I had no idea.
Yeah, and plus, the legal machinery is incredibly slow. Your assets can be frozen for months or even years while the court authenticates documents and waits for creditor claim periods to expire. And all of that is draining the estate with court fees and attorney costs.
Okay, so the goal is to completely avoid that DMV parachute. We need to bypass the probate machine entirely. And that brings us to the actual tools you need to take back control. Let's get into the classic debate, the will versus the trust. A lot of people think they are the exact same thing, but they function very differently.
They do.
A last will and testament is crucial, right? Because it's where you name those guardians for your kids and an executor to handle your affairs. But a will absolutely must go through that ugly probate process we just talked about. A will is basically just a letter of instruction written to the probate judge.
Precisely. The will doesn't magically transfer your house. It just tells the judge who you want the house to go to. The judge still has to authorize the transfer.
Okay, makes sense.
Now, if you want to bypass the judge entirely, you look at a revocable living trust. Think of a trust as a legal container. While you're alive, you put your house, your bank accounts, your investments into this container.
But I can still use them.
Oh, absolutely. You still control it completely. You can sell the house, spend the money, do whatever you want.
Because I am the trustee of my own trust.
Right. But when you die, or if you become incapacitated, the container doesn't die. That legal entity lives on. Your chosen successor simply steps in, takes the lid off the container, and distributes the contents exactly as you instructed.
Bypassing the court.
Completely bypass. It offers privacy, incredible speed, and absolute continuity.
And continuity is huge, especially if you're still alive, but you can't make decisions. Which brings up the powers of attorney. There are two critical ones. And the mechanism behind how they work is so important.
Right.
First, there's the durable power of attorney for finances. This authorizes someone to pay your bills, manage your investments, deal with the IRS if you're in a coma or have dementia. But there is a massive debate in the legal world about whether this power should be springing or immediate.
Yes, and understanding the difference is vital. A springing power sounds logical to a lot of people. It means the legal authority only springs into action if you are officially declared incapacitated.
Right, that intuitively makes sense to me. People think, I don't want my spouse having this massive financial power while I'm perfectly healthy. Why is that a bad idea?
Well, because incapacitated isn't a switch you flip. It's a legal and medical threshold. Let's walk through the reality. Imagine you're in a severe car accident. Your spouse needs to access your individual bank account to pay the mortgage.
Okay.
They go to the bank with the springing power of attorney. The bank manager is going to say, I need letters from two separate physicians swearing under oath that your spouse is legally incapacitated before I can honor this document.
Oh, wow. And getting two doctors to agree to sign a legal affidavit while they are, actively trying to save your life.
It's nearly impossible. Doctors are terrified of HIPAA violations and medical liability. They will stall. So your spouse is sitting in a hospital lobby, panicking, the mortgage is late, and they're fighting with hospital bureaucracy just to get the authority to use your own family's money.
That sounds like a nightmare.
It is. An immediate power avoids all of that. It takes effect the second you sign it. You just have to trust the person you're giving it to.
And alongside that, you have the healthcare power of attorney. This is the person who actually talks to those doctors for you. And from the sources, this needs to have rock-solid IPOA authorization built right into it.
Absolutely.
Because if your agent isn't explicitly authorized under federal privacy laws, doctors can and will legally refuse to share your medical chart with them.
It's true. And you want to pair that with a living will or an advance directive where you write down your end-of-life care wishes. That way, your family doesn't have to agonize in a hospital hallway over whether you'd want to be on a ventilator. It removes the burden of guilt from their shoulders.
Now, here's where it gets really interesting, because you could pay an expensive lawyer to draft all these beautiful, sophisticated trust documents, the immediate powers of attorney, the healthcare proxies, and you could still end up totally ruining the plan. It's called the unfunded trust trap.
Ugh. It is heartbreakingly common. People treat signing the trust document as the finish line.
Yeah, I love the analogy for this. It's like going out and buying a state-of-the-art titanium laser-guarded safe. You have it installed in your house, you paid a fortune for it, and then you just leave all your cash, your family heirlooms, and your gold sitting on the kitchen counter right next to the safe.
That's exactly it.
If you don't actually do the boring, tedious paperwork to retitle your house and your bank account so that they are officially owned by the trust is useless.
Right.
It is literally an empty safe. And your family goes to probate anyway.
You have to physically go to the bank and change the name on the account from Jason Doe to the John Doe Revocable Trust. If you don't cross that final finish line, the whole strategy collapses. And that really leads directly into another trap that overrides even the best laid plans.
Oh, right.
This is a silent override that catches so many people off guard: beneficiary designations.
Oh, this part of the research blew my mind. I'm going to call this the 1995 sticky note rule.
That's a great way to put it. Explain how that works.
Okay, so your 401k, your IRA, your life insurance policies, these are massive assets. But they typically do not pass through your will or your trust. They pass through the contract you signed with the financial institution.
Right.
They pass through that little beneficiary form you filled out when you first opened the account. And that form, that contract, legally overrides whatever's in your will.
Yep. It bypasses the probate court entirely. Contract law beats probate law.
Right. So imagine this nightmare scenario. You get a job in 1995. You fill out your 401k onboarding paperwork with HR, and you name your spouse as the beneficiary. 10 years later, you get a bitter divorce. A few years after that, you remarry. You have 3 kids with your new spouse.
Okay, follow.
You go to a lawyer, you write a brand new ironclad will, leaving every single penny you own to your current family, and then you die.
And because you never logged into the Vanguard or Fidelity portal to update that original 1995 form, the entire retirement account, which has been growing for 30 years, by the way, goes straight to your ex-spouse. The new will doesn't matter. The judge can't do anything about it. The old form wins.
It's brutal. It's literally a clerical error that alters the financial trajectory of an entire family.
Mm-hmm.
And there's another massive mistake people make with those forms, which is naming minor children as direct beneficiaries.
Oh, yeah, that's a huge one.
Let's say a single mom names her 5-year-old son as the direct beneficiary on a $500,000 life insurance policy.
Mm-hmm.
If she passes away, what happens?
Well, in a place like Massachusetts, the legal age to inherit is 18. A 5-year-old cannot legally own property. So the court has to step in, appoint a financial guardian, and lock that money down.
Right.
And then on the morning of their 18th birthday, the court is legally obligated to hand that child a check for $500,000.
I mean, I don't know about you, but giving an 18-year-old $500,000 with absolutely no supervision, no life experience, and no guardrails is a disaster waiting to happen.
Right.
Buying a Lamborghini is probably the best case scenario there.
Yeah. Exactly. This is why you designate a trust, not the minor child, as the beneficiary. The trust catches those funds, and your chosen adult trustee manages the money for the child's college, medical care, and housing until they hit a mature age, like 25 or 30, whatever you specified in the document.
And the complexity just keeps multiplying when we look at modern assets. Because we aren't just passing down physical houses and bank accounts anymore. What happens to your digital life?
This is a massive blind spot for almost everyone. Think about your password managers, your cryptocurrency wallets, your Apple ID. If you die, tech companies do not just hand over your passwords to your grieving spouse because they ask nicely.
Right, they don't care.
They don't. They are bound by incredibly strict federal privacy laws and terms of service.
So if you don't have a plan, or if you haven't set up legacy contacts in your Apple or Google settings, those assets, like the thousands of family photos on the iCloud, the crypto keys, the emails, they can be lost forever, just permanently locked behind corporate red tape.
It really highlights how comprehensive planning needs to be today. It even extends to pets. Pets are legally considered property, so you can't leave $1,000 to your golden retriever.
As much as we might want to.
Right. But you can set up a pet trust which legally binds a human caretaker to use a specific pot of money exclusively for your dog's vet bills and food.
Okay, this brings up the elephant in the room. With so many moving parts, wills, trusts, springing versus immediate powers, aka unfunded safes, the 1995 sticky note rule, digital lockouts, how does an ordinary person, let alone an exhausted, stressed-out parent, possibly navigate this without making a devastating DIY mistake?
Well, they usually can't. That is exactly why trying to do this with a $50 online template is a gamble. An online form doesn't know the quirks of your state's laws, and it certainly can't ask you probing questions about your family dynamics to uncover blind spots. You really need a guide.
And that naturally brings us right back to Pooja Aurora, because this wall of complexity, this overwhelming feeling of how do I not mess this up for my family, this is exactly the wall she hit.
Yes. If we connect this to the bigger picture, her journey into this specific area of law is profound. We mentioned her son, Ishan, earlier.
Right.
As he grew, he started suffering from severe headaches, which led to intense, chronic physical pain. Pooja actually put her entire legal career on hold. She already had a law degree from India, but she became a full-time stay-at-home parent just to manage his daily care and medical appointments.
And the situation just kept escalating, right?
Right.
Eventually, they reached a point where the local school system in Lexington simply could no longer meet his profound, specialized needs. They had to make the agonizing decision to transfer Ishan to a specialized residential program, the New England Center for Children. As a parent, making the call to send your child to live away from home because it's medically necessary, I mean, the grief and the exhaustion must have been paralyzing.
But what she did next is what's truly remarkable. She took that devastation, that absolute lack of control, and redirected it into a laser-focused purpose. She knew she had to secure an ironclad future for Ishan for the day she and her husband were no longer around to advocate for him.
So she went back to school.
She did. She went to the Massachusetts School of Law to sit for the bar, and then she went to Western New England University specifically to master estate planning and special needs law.
But here is the kicker from our research. Even with her legal background, when Pooja went to hire an estate planner to set up Ishan's special needs trust, she had a terrible experience as a client.
She really did.
She walked out of that lawyer's office feeling, quote, unsettled. She didn't really understand the mechanics of how the complex documents actually work together. It felt transactional, cold, and confusing. And that lack of peace of mind is what directly led her to open her own firm, My Special Legal Planning, in August 2024.
She essentially built the law firm that she desperately wished had existed when she was the terrified client. She understands on a visceral level that parents aren't walking into an office to buy legal paperwork. They are trying to buy the comfort of knowing their children will be safe.
And you can actually quantify the impact of that personal motivation. Her husband did this amazing analysis of her Google business profile. She has over 110 five-star reviews from families across the greater Boston area.
Wow.
And the words that keep popping up in these reviews aren't brilliant litigator or aggressive bulldog. Out of those 110 reviews, 37 specifically highlight her immense patience, and 66 reviews single out her clarity.
Clarity is everything in this field. The reviews note that she will sit there and explain the exact same legal concept 3 different ways in a single meeting if that's what it takes for a client to truly understand the mechanics of their plan. She makes the complex feel incredibly simple.
She even writes up detailed meeting notes after the sessions so that overwhelmed parents can review the information at their own pace when they get home. Like, she isn't just handing over a stack of paper and an invoice. She's making sure they know how the machinery works.
It's a completely different standard of client care, rooted entirely in empathy.
So, what does this all mean for the listener? Let me push back on this a bit. Look at my situation. I'm relatively healthy. I don't have a child with severe medical needs. I just want a basic will and a standard trust to make sure my spouse gets the house.
Okay.
Going to someone whose entire origin story and expertise are built around highly complex special needs trusts, it feels like overkill. Like hiring a Formula One mechanic to change the oil in my Honda.
Yeah.
Why wouldn't I just use a cheaper general practice lawyer?
I get the analogy, I do, but it actually works the exact opposite way in practice. Empathy and clarity scale perfectly. The extreme patience required to navigate a traumatized family through a special needs plan translates beautifully to a young couple setting up their very first basic will.
Oh, that makes sense.
Yeah, she works extensively with healthy young families. She works with immigrants who are terrified of making a misstep in U.S. estate laws, which are vastly different from their home countries. She works with adult children scrambling to protect aging parents.
And she is practically bending over backward to remove the intimidation factor. She does evening meetings, weekend consults, she does things remotely, and she'll even meet people at the local library so they don't have to walk into a stuffy law office.
Exactly. She even hosts free Saturday estate planning workshops right in her office in Lexington. It's a completely zero-pressure environment where people from the community can just walk in, learn the basics, and realize that this protection isn't just for billionaires, it's for anyone who loves their family.
Which brings us to the final takeaways from our deep dive today. If you learn nothing else, remember, this estate planning is not a one-and-done chore. It is an ongoing act of love. You need to review your plan every 3 to 5 years, or after any major life event. A marriage, a divorce, a new baby, a death.
Because the perfect, flawless estate plan you created in 2015 might be a complete, devastating disaster in 2026. The tax laws change, the legal thresholds change, and most importantly, your relationships change.
So we want you to take just one action this week. Don't let this be another intimidating thing you put on the someday list. Start incredibly small. Pull up your 401k or your life insurance portal online right now, literally today, and just check who is listed on that beneficiary form. Defeat the 1995 sticky note rule. Make sure the money is going exactly where you want it to go.
And if you don't have a plan in place at all, don't wait for a medical crisis or a sudden tragedy to force your hand. The time to build the parachute is when you are clear-headed and safely on the ground. For anyone listening in the Massachusetts or New Hampshire area who feels overwhelmed and is seeking that rare combination of elite legal clarity and profound tested empathy, you can reach out to Pooja Arora at My Special Legal Planning. They offer a free initial consultation just to start the conversation and see where you stand.
It's all about securing that elusive peace of mind. But as we wrap up, considering everything we've unpacked today, from intestacy laws destroying blended families to empty safes to the digital lockouts,
This raises an important question. In an era where our digital footprints are thousands of photos, our cryptocurrency and our online lives might theoretically exist forever on corporate servers, is an estate plan really just about passing on your physical wealth? Or is it actually becoming the only reliable way to curate your final legacy in a digital world that never truly deletes anything?
that is a wild thought to end on. Because if you were hit by bust tomorrow, well, it's not just your bank accounts left behind anymore, it's your entire digital ghost.
Make sure someone you trust holds the key.